Let's take a look at who can bring a lawsuit in regards to employment law. Most employment laws enable employees to enforce their rights through lawsuits against their employers. As an exception, if an employee reports a safety hazard to OSHA and the inspector does not agree that there is a problem and the employer is not cited, no course of legal action is available to the employee. Likewise, if the appropriate officials of the National Labor Relations Board decline to bring a complaint regarding an alleged unfair labor practice, the employee is out of luck. Suits and discrimination cases can be brought by individuals or the EEOC, but because only a very small percentage of cases it receives go to court, the burden of taking legal action falls mainly on individual employees. Employment lawyers accept only an estimated 5% of employment discrimination cases brought to them. Lower wage workers, for whom provable damages are relatively low, are particularly likely to have their cases turned away. Considerable managerial time is spent when a lawsuit's filed, responding to requests for records, answering interrogations, and giving sworn depositions regarding the facts of a case. The best advice is to answer questions truthfully and succinctly and to have documentation to back you up. Settlement negotiations are likely, both at this point and throughout the course of litigation. Employment law cases are brought in both state and federal courts. Where the case will end up depends on factors like the legal basis for the claim or where the parties reside or are incorporated. A case that goes into the federal court system starts at the district court or trial court level. The role of the district court is to establish the facts of the case and reach a decision about employees' claims. However, many cases filed against employers are dismissed without a trial because the court determines that even if the allegations are true, they're not sufficient to support a legal claim. If a case does go to trial, the plaintiff bears the burden of proof to show, generally by a majority of the evidence, that his rights were violated. Cases that go to trial are sometimes decided by juries and other times by judges. District court decisions can be appealed by either party to a federal appeals court known as a circuit court. Appeals courts typically accept the facts of cases as given and focus on whether the lower courts properly applied the law in deciding cases. Appeals courts' decisions can be appealed to the U.S. Supreme Court. However, because the Supreme Court exercises its own discretion as to which cases it hears, and it hears relatively few cases each year, rarely does a case go that far. Judges enjoy considerable latitude in deciding cases. While courts sometimes change their minds about the law, they have a strong preference for adhering to prior decisions known as precedents, or at least giving the appearance of doing so. This desire for consistency and stability in the law is captured by a phrase which means, "let the decision stand."